This is the time we have, my Lord, distributed amongst us, my Lord. And we have been very, very careful, my Lord, in
Oh, that's nice.
Lord, my learned colleague, 30 minutes, Maninder, 20 minutes, Manisha, 20 minutes, J. Sai Deepak, 20 minutes, then all are 5 minutes. Then I would request at the end to give me 5 to 7 minutes. 7 minutes is outer limit, my Lord.
So, Aishwarya, Maninder,
I'm sorry, my
Manisha, and Sai, they will go 30, 20, 20, 90 minutes. So, we'll be done with their submissions by 12:45. 12:45, they would have finished. And then the others who have about 5 minutes, 4 minutes, we'll ask them, we'll see what to do. And we'll give you 5 minutes at the end at 12:55.
5 to 7. I'll not repeat anything, but I would like to say something as a concluding prayer, my Lord, before I
All,
launch.
all right. Yes, Ms. Bhatti.
My lords, we had circulated a note, my lords, last week and 3 compilations. And we have, my lords, circulated 1 additional compilation yesterday, my lords, yesterday evening. Additionally, my lords, I will also be referring to note 2 of the learned SG, my lords, because the aspect with regard to child.
Yes.
And my lords, at the outset, I must also say, my lords, that though the application is filed on behalf of NCPCR, but we had to take lots of inputs from the Ministry of Women and Child Development and also CARA. So Lordship may take it that these submissions are, my lords, comprehensively from these 3 bodies, my lords.
Which submissions you will be referring?
My lords, we filed our submit. I made
Yes,
a brief.
we have your list of.
Lordships
you
have
have a
my
written
submissions,
submissions.
my lords. It is in 3 parts, my lords. Part A, Part B, and Part C. I can actually confine only to Part B because other aspects are which are covered, but that's just for the sake of completion, my lords. It's a short note. And there are 3 compilations, my lords, A, B, C, and 1 filed yesterday, D.
So we have now a master index by Ms. Bhatti.
Please, my lords.
Then we have Part A compilation, Part B compilation, Part C, and Part D compilation.
Please,
Then
my
your
lords.
written submissions.
Please, my lords.
That's the.
Lordships, please. My lords, Part A of my note is, my lords, where I'll just give a brief wherever your lordships want me to stop and elaborate.
Yes.
I'll just give an outline, my lords. So the first Part A really deals with 2 submissions, my lords. First, I have tried to submit that there's a basic structure of the marriage, and that is a union of man and woman. The second submission I have, my lords, is gender fluidity. I'm not elaborating, my lords. I'm just stating my propositions. And the second submission I have is that gender fluidity is impermissible where cisgender is core. And ignoring rationale of valid classification amounts to perpetuating inequality. Then I've given examples of areas which have been reserved specifically for women. Because if these spaces are diluted in any manner, then what will be lost is really the cause of women's equality, women's well-being, women's empowerment. That is my second point, my lords. And I've given examples like women's recruitments, spaces which are specifically for women, women's washrooms, women's correctional homes, women inmates, welfare homes, ladies' barroom in the Supreme Court. When your lordships recognized in NALSA transgenders as a third gender, your lordships did not, using the expression that Mr. Datar did, my lords, did not retrofit in the 2 existing genders. Your lordships identified them as a third gender. So, my lords, it's very critical that gender fluidity cannot be permitted in areas where cisgender is core. That brings me, my lords, now to Part B. That is specifically with regard to children. And my lords, the preposition that I have is welfare of child is paramount and sacrosanct and cannot be opened, exposed even for an iota of potential compromise or uncertainty. My lords, for the first preposition, that is the child has a right to be born and raised by biological parents. My lords, for this I will rely on note 2 of the Learned Solicitor General for India, my lords. Your lordships will kindly have page 39 to 49 of that note. There are some research papers also which is there in their compilation, but Learned SG's note quotes the paragraphs that are relevant. If your lordships will kindly take that with me, my lords, page 39 of note 2 of Learned SG. Only for the purpose of these two prepositions, that the legitimate state interest of ideal mode of child rearing. My lords, all children are naturally born only to heterosexual couples. And now, my lords, when I take your lordships through the architecture of my lords laws which are relating to children, there are no competing rights in this space, my lords. The only sacrosanct paramount right is that of the child. To the extent that sometimes a child may need to be protected from himself. The entire, my lords, architecture of these laws are from the concept of welfare of child being paramount. So, my lords, my respectful submission is, if your lordships will, my lords, have page 39 of Learned SG's note, my lords.
Which note? Ms.
Note 2, my lords.
Note 2.
Note 2 of the Learned SG. This chapter, my lords, the
Violation 2. Note 2.
Note 2. PDF page 39.
my lords, it's running 39. PDF should be PDF of 44.
Yes.
44 it could be, my lords. 42. I'm grateful. 42, my lords.
42.
The legitimate state interest of ideal mode of child rearing. Am I,
Yes.
right, my lords?
Page 42 starts with note 2, fundamental rights, para 59,
My lords, this is para 63.
60. Very well.
Bottom.
Got it.
Yes.
My lords will see, my lords, this is for the preposition that legitimate state interest of ideal mode of child rearing. Now, lordships will, my lords, the fundamental point is that a child can only be naturally born through a heterosexual couple. And therefore, the special significance of recognition of heterosexual marriages cannot be understated from the point of view of child, birth of child and bringing up of the child, both. My lords, there are some very interesting papers that have been put together, my lords, in the research of this note. And my lords, these papers show that fathers and mothers both play complementary roles in upbringing of the child. And state is justified in treating homosexual and heterosexual unions differently for that purpose. The first paper, my lords, that is quoted in para 66 is straight is better while law and society may legitimately prefer heterosexuality. Is a paper, my lords, from a professor of law, my lords, of Case Western University, Ohio. Your lordships will find that at page 353. The entire paper is there in compilation, volume 8 of Learned SG, my lords. It's mentioned here. The relevant paras are quoted here. And if I can draw your lordships to the last para that is quoted at the next page, my lords.
Which page?
Marriage, my lords, I am at page 41, the noted page 41.
Yes, but which compilation? Same thing.
Note
Same thing.
OS.
Learned SG's note, my lords. I was just giving that the complete paper is there, but the relevant portions are here. So marriage is not a factory for childbearing. Marriage exists to encourage men and women to create the next generation in the right contexts, and simultaneously to discourage the creation of children in other contexts out of wedlock in fatherless homes. Well, it's the next paper that's in para 68 is marriage from a child's perspective. How does family structure affect children and what we can do about it? Please see the highlighted portion. It is not simply the presence of two parents, as some have assumed, but the presence of two biological parents that seem to support child development. Children in single-parent families, children born to unmarried mothers, children in step families or cohabiting relationships face higher risk of poor outcomes than do children in intact families headed by two biological parents. Parental divorce is also linked to a range of poorer academic and behavioral outcomes. The next paper, my lords, this is my lords, Pennsylvania University law professor. The next chapter is, the next paper is Tradition, Pluralism and Same-Sex Marriages. This has 4 authors, my lords. The paper your lordships will find in volume 8 of the Learned SG's compilation. Please see, my lords, the highlighted portions in the second para. To date, the research on child well-being and family form bears out that children thrive on structure, order, routine, stability, continuity, certainty, and clarity. The evidence shows that conventional beats unconventional every time. This means that complexities and ambiguities of non-traditional families come at a price.
But Ms. Bhatti, our law permits a single person to adopt a child.
My lords, permit me to come to that now.
Yes.
Your lordships will see this, my lords. The learned SG did not place it. Lordship may
Right.
note that this is, my lords, from page 39 to 49 on both the prepositions. The first is, my lords, that the legitimate straight interest, and that I showed to your lordships, and that there are some papers, my lords, on there is lack of data to establish equivalence with biological heterogeneous upbringing of children. Lordship may see it. I just brought it to your lordship's notice because it was the learned SG left it to me, my lords. to
Right.
bring it. Now, please come back to my note, my lords. Your lordships will see.
Which is your note now?
My lords, your lordships had my note welfare of child.
One second, yes.
I'm sorry, this
To go back.
I've
written
opened so
submissions
many.
on behalf of.
Yeah.
So I've said only NCPCR, but it's also the ministry and CARA.
Written.
My lords will have para 8, my lords, at internal page 5, at page 5 of my submissions. This I have placed. The second preposition is,
I don't
Just
know
a
which
moment,
page,
just
sorry.
When Ms. Bhatti, we are
I'm
still
sorry, my
looking.
lords. Yes, my lords.
Right.
Para
This is
eight.
para 5 at page 4.
No, but which note is?
This is the Ms.
Note,
Bhatti's
you're
note.
talking of note.
There's
two,
only
you
one
said.
note. Written
Yes,
sub-
my lords. Yes, my lords.
Gender fluidity, right?
Yes, my lords.
This-
That I just mentioned, and then I came to part B, which is at page 5. I hope my lords justice call have my lords the
Yes, I have it. That welfare of children is paramount and
very
sacrosanct.
grateful, my lords.
Click on Aishwarya Bhatti and you'll get.
Eight. My lords, I only touched the prepositions in part A because it has been extensively dealt with, and I am at, my lords, para 10 now, my lords.
Para 10.
State as parents patriae of children, my lords. And this is critical, my lords. I will show to your lordships the Juvenile Justice Act, because the entire architecture, when it comes to the legislations with regard to welfare of child, my lords, it's the child alone who has rights. And my lords, it's in sync with the UN Child Right Convention. It is in sync with the constitutional philosophy and ethos. And please see how the Juvenile Justice Act deals with. May I request your lordships to take my compilation A. I put the acts there so I can show.
Why don't we go through your written
Written
note?
submission.
That might be much better so that, we can get
Then your
the
lordship will
structure
put-
in our mind.
Wherever necessary, we'll go there.
So, my lords, I'm not touching this aspect of parents patria any more than mentioning it that it's the
Absolutely.
settled.
Very well settled, so you don't have to
Right.
read out the case law.
Paras from your lordship's judgment. Then your lordships will see para 11, my lords. The architecture of child legislations is so pervasive and significant that it even extends to covering beneficially the mother of the child. My lords, human child, my lords, I don't have to state it, but human child really is one of the most helpless childs of all, my lords, living beings in the nature. And it needs all pervasive, intense and indulgent care in the early years. And therefore, my lords, mother has been strongly protected, not just in the Constitution, but also in the Juvenile Justice Act, the Maternity Benefit Act.
Yes.
My lords, Article 42, I have, my lords, adverted to in para 11. And my lords, para 12, I have stated that a gender may be fluid, but the idea of mother cannot be. And therefore, my lords, it is very pertinent and important that this is given a very careful consideration. The whole perspective is, my lords, that what I'm presenting for your lordship's kind consideration is from the point of view to show to your lordships that this architecture, how it is going to be, my lords, impacted by a declaration and reading into Special Marriage Act.
militate against a situation which is, forget about the gender part. Where there's sometimes only a father who has
We
to
have
care
gone
for
beyond
the
motherhood.
children.
We have gone into parenthood today.
Yes, Malaj.
Because there are, as Mrs. Kohli is mentioning,
Please,
there
Malaj.
are single
Parent,
parents.
Please,
Now,
Malaj.
male or a
there
female.
is a death at childbirth.
Please, Malaj.
The mother unfortunately dies of disease or accident.
Please,
The
Malaj.
compulsion.
Then there is no question of the caregiver being the father,
Please,
regardless of. Likewise, there are adopted children
Children.
Yes,
of
Malaj.
only of males
Please, Malaj.
by men, the fathers. So it's gone beyond the concept of, in that sense,
I bow down.
in that sense, when the Constitution envisioned it, and some of this parents' patria, interestingly, if you see the quotation of Lord Justice Lindley, he talked about husbands, guardians, and fathers.
Please, Malaj.
So where that was a situation where women didn't have agency, women were even seen as wards,
Please, Malaj.
right? So therefore, the question of guardianship was that with men.
Please, Malaj.
So it's an evolving,
I bow down, Malaj. I bow down to what is
but
falling from
what
your
is
lordships.
central to this, yes, is unchanging, which is the welfare of the child.
Child.
Please, Malaj. So, Malaj, my respectful submission would be, Malaj, that your lordships may see it from the perspective that this method of naturally born heterosexual couples bringing up their children is the ideal mode. And the law and the entire regulation has provided for, my lords, children who do not have that. From that perspective, please see now, my lords, the aspect of adoption. I have given one example in para 13 of sponsorship, which is available to only widowed, divorced, or abandoned mothers to seek sponsorship for their children. That's a protection under Section 45, specifically available only to this category of women, my lords. Then please see, my lords, please see para 14. My respectful submission is adoption is not an alternate to biological birth, my lords. My respectful submission is that adoption is a mechanism to find
Equally,
best
our law does
possible-
recognize that you can adopt for a variety of reasons.
Yes.
You may adopt even though you are capable of biological birth.
Please,
You can adopt if you don't want biological birth.
please, my lords.
There's no compulsion to have biological children. Therefore, our law does recognize
Please, my lords.
the fact that there may be situations within this ideal of a cohabiting family with father and mother of of a heterosexual gender family having their own biologically born children. But that's not
Please.
how our law is postulated also, right? What happens if, suppose, between the pendency, during the tenure of a heterosexual marriage, one of the spouses dies, then the other spouse really assumes the character of a father and a mother, depending on, isn't it? So that is something which our law recognizes.
My lords, I bow down. The law recognizes again from the perspective of the child. Your lordships have held that there is no fundamental right of adoption.
No, I think we may differ on that, because even if you go back to tradition,
Yes, my lords.
the right of a grandfather to take in adoption
Please, my lords.
the son of the daughter, what is classically known as one of the approved forms of forms of, yes, having a child,
Yes, my lords.
Pitrika Putra.
Please, my lords.
So that is a known notion. So it is not that this is no sanction. It is hallowed. It's hallowed in
My lords,
tradition.
I bow down, my lords.
Therefore, to say this is an exception may not be appropriate.
My
And
lords,
why did even in some schools, even grown women, widows are enabled to adopt? Why? There's another purpose there.
my lords,
And even there are situations where adoptions take place, and thereafter there is biological birth.
please.
That too happens. So
My
there are
lords.
any number of situations where adoptions is the norm.
My
But
lords,
yes, you're right. But then all this is serving to emphasize and heavily underline that there is a normal and these are exceptions.
my lords, my respectful submission is not of exception. My endeavor is to present to your lordships that all of this is crafted together from the perspective of child being at the core of it. It's
This is
not
different.
right that in yours,
Ms. Bharti, that you need not labor at all. That
May
you
not
should
be,
have-
that may not be.
But the
See,
welfare of the child is paramount, obviously.
Definitely.
True, true.
so my lord, adoption is, I want to show to your
But the
lordship.
means of realizing that welfare are numerous. The pathways are
I bow down.
numerous.
I bow down. In fact,
Some of
adoption,
them are matter of choice, some are matter of compulsion.
Function.
I bow down, my lords, and the Kara guidelines
But
actually.
tell us one thing, is it your case that a right which is otherwise available to an individual to adopt a child is taken away because that individual is in any relationship otherwise than a heterosexual marriage?
That is right, my lords. And that is not just true for adoption. That is true for assisted reproduction, which is now regulated by the assisted
So
reproduction.
if two people if two people are in a live-in relationship,
Yes, my lords.
does that mean that therefore, because of the fact that the two people are in a live-in relationship,
Yes.
maybe a heterosexual couple, that they will not have a right to adopt?
Not in the, under the existing law, my lords. Not just adopt,
But
my lords.
is the right of one of them to adopt taken away because she or he is in a live-in relationship?
My lords, one of them can adopt. But the only couple relationship that adoption
It's a heterosexual
and
relationship.
surrogate reproduction, all three of them only recognize one kind of couple. That is a heterosexual married couple.
Therefore, no. But therefore, if two people, if a
Yes.
heterosexual couple is in a live-in relationship, one of them can certainly adopt. Or is it Kara's case that we will deny you the right to adopt because you are in a heterosexual live-in relationship?
No, my lords. I permit me to show it to your lordships the Kara
If I
regulation.
may paraphrase your argument, it is
Yes,
like
ma'am.
this. The public policy consideration which you are actually mooting or advocating, or rather stating, is that yes, we allow adoptions by single, let's say males, single females, in their capacity as single males or single females.
Please, my lords.
But
But not
the
with
the
their
moment they enter
relationship.
into either a
Union or
same-sex relationship or another kind of live-in relationship, that relationship is not per se recognized.
I bow down, my lords.
So the only recognition of a relationship of father and mother is where there is a
Heterosexual marriage.
Lordships, please. And that is true not just for adoption, but also ART Act.
My question is different. If people are in a live-in relationship,
Please, my lords.
then is the right of an individual in a live-in relationship to adopt taken away by virtue of the fact that they're in a live-in relationship?
My lords, they will not be, so only one parent can adopt as a
Fair
single
enough.
mother or the single
That we've got.
lordship.
But your circular says something to the contrary.
No,
Because your circular says that the moment you are in a live-in relationship, albeit in a same-sex relationship, then you cannot adopt even as a single individual.
my lords, I will quickly take your lordships through the architecture of the
Ms.
JJ Act.
Also,
Yes,
keep in
sure.
mind one more fact, Ms. Bhatti. Besides the fact that Honorable the CJI has pointed out,
Please, my lords.
there is that condition. And what if, and that what if will be important, that somebody per se says that he or she is not in a live-in relationship, you probably have a format or something that a person has to sign or say this for you to satisfy yourself, and subsequently does, then what happens? Will the child be taken back?
My lords, there is provision for disruption and dissolution in adoption also. There, my lords, it is carefully crafted because child who is adopted will become a child of that person for all purposes, for inheritance,
That's right.
for all other rights. So, my lords, it cannot allow this. There can be no uncertainty in, my lords, in these matters when it concerns.
Person, if he or she elects to adopt, will for the rest of their lives have to undertake that they will never be in a
No, no, my lords,
relationship.
there is no undertaking like that.
Unless it's a case of
No, no,
them
my lords.
actually marrying.
No,
What
my
is
lords,
it that you're putting?
There is no
What
undertaking
is
like
it that you are?
my lords, what I will tell your lordships how they are constructed is that a heterosexual married couple has to also have 2 years of stable relationship of marriage before they can adopt. It's not like they can, and they have to have consent from each other.
And if
It-
it's a single parent,
If it's a single parent, then there are other considerations. What is their age? What is the gender of the child? What is their gender? I want to quickly show to your lordships the architecture under the JJ Act, the Kara. Lordships, Miss my lords, that compilation A, I have put all the 3 acts.
Sorry.
My lords.
all
Mr. Bhatti, what I can get what sister is saying is, suppose there is a single adoption.
Please, my lord.
There is an adoption by a single person. After a couple of years, child is being brought up by that parent, and he decides you can't guarantee the future what will happen. So he decides to have a, say, to begin with a live-in relationship. That's not a disqualification.
Not at all.
It will be there. So how do you explain this?
My lords, I will quickly take 5-10 minutes and take your lordships through the architecture, starting with the
Ms.
CJI.
Pati, we can recognize 2 points which you have made. One, if a couple wants to adopt a child, then our adoption regulatory regime only recognizes the right to adopt when you are in a heterosexual marital relationship.
Please, my lords.
All right? That's your first point.
Please.
We understand why and what the public policy underlying that is.
Please,
That
my lords.
if you have to be a couple, if you have to be a mother and father, you must be necessarily in a heterosexual marriage before you can both adopt a child as a couple.
Please,
That's
my
your first proposition.
lordships.
What we are asking you really is on something slightly different, which is nonetheless, our law recognizes the right of a single individual to adopt.
Yes, my lords.
And the question, therefore, is, and we take it that's your position also, that the right of a single individual to adopt is not affected by the relationship which that single individual may otherwise have, whether it's in the nature of a live-in relationship, which is heterosexual, or a live-in or a relationship of a same sex. So long as you are adopting, as a single individual.
Lordships. I bow down, my lords. That is my stated position. And my lords, your lordships will appreciate that because the law.
So we therefore take it that even a same-sex couple,
Yes, my lords.
or let me rephrase it, an individual in a same-sex relationship
Please, my lords.
is not precluded from adopting a child. We
Please,
take
my
that as Kara's statement of position.
Yes, that is the mandate of Juvenile Justice Act.
Please.
That is the mandate of.
If I may just make one more statement,
Lordship.
you will agree with. A single parent
Please, my lord.
who adopts remains a single parent, there is no difficulty. The moment she enters into a matrimonial relationship
Please, my lords.
with, it's a heterosexual relationship,
Please, my lords.
then the husband becomes the father,
Lordships.
correct? The adoptive father, like she's the
Lordship.
adoptive mother. So then the child, as a consequence, becomes the heir in the event of death to the properties of either,
Yes, my
and rather both.
yes.
On the other hand, if the single parent enters into a same-sex relationship, then the adoptive child continues to be the adoptive child of that adoptive father or the mother,
Please,
and no more. Full stop.
Yes.
This is your proposition.
Lordships. My
What
lords,
you say is.
So
that,
therefore,
it doesn't
sorry,
recognize
just to take one thought further, what you're driving at here is the stability. Because even in the event of disruption of the family, like in the case of marriage, there is a divorce. The relationship of an adoptive child continues.
lordships.
Whereas since there is no marriage and there is no marriage recognition, that stability would be undermined if you recognize.
I bow down, my lords. I bow down to your lordships. My lords, Justice Narasimha had a point.
See, I was
My lords, in
looking
fact,
at
Kara has
your argument.
a fast track method for step parent adoption also. It may happen that somebody has a natural born child and she becomes a divorcee or a widow and she remarries. So her child can be adopted. There's a mechanism that is.
Yes.
My lords, it's actually, it's very carefully crafted. My lords, we are a culture of my lords,
Perhaps-
Yashoda Mata and also Devki Mata, my lords. So
Perhaps-
both, my lords, one who gave birth and one who reared the child.
We will see those regulations. Perhaps there might not be anything formulated to say it's prohibited. But while hetero marriage might be recognized, same sex, the rules might not have provided any recognition. We'll have a look at those rules. and-
Actually, my lords, that is why live-in is also not recognized, because live-in also is what Mr. Sybil was mentioning yesterday, the within, the concentric circles. The without is not recognized for live-in. Live-in are, my lords, now recognized under the Domestic Violence Act
A
120.
living couple cannot adopt a child as a couple.
Yes, because they can walk out
That's
of
fair enough.
relationship anytime.
Fair enough. Fair enough. Then we understand what the public policy precept underlying it is.
Please, my lords.
But the existence of a live-in relationship does not prohibit one of the parties from seeking to adopt a child
Yes, my lords.
as an individual.
Yes, my lords.
See, you're looking at it from the perspective of the child, which is that the
Lordships.
child is most benefited in every formation. At least there is one person responsible for that.
I bow down.
That stability is what you're actually driving at. The
Hello.
core, at the
And
core
the
of
fact that
adoption.
one individual has adopted, that right to adopt or the continuance of that adoption is not affected by any subsequent change in the marital status of that individual who has adopted.
Please, Manoj. Please, Manoj. Manoj, in fact, the ART and Surrogacy Act, the validity of some provisions are being considered by Court 5. There are a clutch of petitions that have challenged some provisions. And Manoj, there was a point that was sent to the National Board for reconsideration. There's a very Manoj, well-equipped national board under ART and Surrogacy, because they are also Manoj, in a manner only recognizing this couple of heterosexual married couple as a relationship. And Manoj, single women are allowed under the ART. And only widow and divorced women are allowed under
Then, Ms.
surrogacy.
Bhatti, can we then summarize your submission in the following terms? That just as there is no recognition, according to you today, in the state of our law, of a same-sex marital relationship, which is legislatively recognized, parallelly, there is no recognition in our law today of the right of a same-sex couple to adopt a child as a couple.
Lordships. Yes, Manoj. I bow down, Manoj.
And that is based on the foundation that a child must have a stable family existence, and which you postulate would exist in the case of a heterosexual marriage.
My lords, would your lordships just make a note of the sections that I am, my lord,
Yes, yes.
giving to your lordships? The Juvenile Justice Act, my lords, I wanted to show to your lordships, it is at page 82 of my compilation A. I wanted to show chapter 8 to your lordships. And before that, I wanted to show some definitions and some general principles which are in section 2 and section 3. My lords, those general principles are very, very critical, my lords, from my perspective, because that is really an
Provisions you want us to see?
My lords, I want to draw your lordship's attention to some definitions in section 2 and general principles in section 3, my lords.
Which are the definitions section 2?
My lords, the definition sections, there are 3 kinds of children who are available, my lords, free for adoption. My lords, abandoned child, orphan child, or surrendered child. My lords, this is
It's 82, volume compilation 1, I think.
compilation A, my lords, we are calling it, and lordships will find it.
Printed 87, actually.
Yes, my lords.
Printed
Page 82,
87.
it starts, my lords.
Printed 87.
Compilation, which compilation is this?
Compilation A, my lords.
Yeah, no? In a
Okay. All right.
Also, 87.
Printed 87.
You have
It's
87.
index and 87 it starts, my lords.
87.
Yes.
So these 3 definitions, your lordships will note, my lords, abandoned child to 1. Then, my lords, please see a definition of adoption itself. Process through which adopted child is permanently separated from biological parents and becomes lawful child of adoptive parents with all rights, privileges, and responsibilities that are attached to a biological child. Best interest of the child means the basis for any decision taken regarding child to ensure fulfillment of his basic rights, needs, identity, social well-being, physical, emotional, intellectual development. Child means anyone below 18. Please see 15, child-friendly, 16, child legally free for adoption. Please now come down, my lords, to orphan at 42. Section 2, subsection 42, orphan. Then, my lords, 49, prospective adoptive parents, same as 57. Now permit me to, my lords, take your lordships. A surrendered lordship will note is 60. Section 2, subsection 60 is surrendered child. And sponsorship, an example of which I gave, my lords, is defined at 58. My lords, the general principles, my lords, that are in section 3, there are total 16 principles, my lords. They, my lords, they've been culled out from the United Nations Child Rights Convention. And my lords, I want to highlight to your lordships the aspect of number 1, presumption of innocence. My lords, the principle of best interest to develop full potential, principle of family responsibility, positive measures, my lords, and I want to read this one, my lords. All resources are mobilized, including those of family and community, for promoting well-being, facilitating development of identity, providing an inclusive and enabling environment to reduce vulnerabilities in children and the need for intervention under this act. This act is not to promote adoption. This act is to make sure that there are less and less interventions under this act.
You are reading from section 3,
Section 3, Principle 6, I placed.
sixth one. Okay.
That's positive measures.
Continuous. 3:35. Started with meeting.
My lords, your lordships will appreciate. Just reminding your lordships of X versus Union of India, my lords, judgment that my colleagues have relied on. In fact, we were fortunate that your lordships gave us the privilege to assist your lordships in that. Medical termination of pregnancy is the border in our respectful submission where the individual rights end. When it comes to, my lords, child that's already born or unborn in the case of ART and surrogacy, it's the welfare of child that alone is the underlying basic principle, my lords. So the parameters will be completely different. My lords, in Navtej, in X, in Nalsa, your lordships were dealing with competing rights. Marriage as an institution, with procreation being such a fundamental core to it, if your lordships read spouse in the Special Marriage Act, my lords, it is going to have impact, my lords, that polycentric spider webs, my lords.
That has been already argued.
It's going to impact the children laws the most in ways that we can't even fathom today. Because children need that certainty of law, that conformity, my lords. And the only reason why any other relationship, though there are other kinds of relationships which are recognized in other laws, go to, my lords, great lengths to protect their children from when they can vote, when they can marry, when they can drink, when they can. And, my lords, the right of repudiation, the right of non-waiver of rights. These are the principles on which they have all been founded. The right to a fresh start, the POXO Act, the entire architecture, consent is immaterial. An independent thought, your lordship said, even a minor spouse would be covered. The entire, my lords, architecture of your lordship's judgments and the statutes has been from the prism of the child and none other. My lords, it's not in my compilation, but there is, my lords, some lines from Justice Bhagwati, my lords, in the judgment of Lakshmikant Pandey versus Union of India. This is 1984 2 SCC 244. Just want to read 2 lines to your lordships, my lords. This is the judgment where your lordships were dealing with the problems of inter-country adoption, and the entire infrastructure, the entire regime of Juvenile Justice Act and CARA came by virtue of your lordships nudge and push in this judgment, my lords. Para 6, just 2 lines I want to read to your lordships, my lords.
Then aren't you serving the petitioner's cause by pointing to this vacuum and what this court did?
My lords, my respectful submission is your lordship may go the slowest when it comes to rights of child.
Yes.
My lords, para 6, just 2 lines, my lords. My lords, I'm sorry, my lords, I'll just read. They're just 2 lines, my lord. Justice Call may kindly bear with me, my lords. This is 1984 to SCC 244, para 6, just 2 lines, my lords. It is obvious that in a civilized society, the importance of child welfare cannot be overemphasized because the welfare of entire community, its growth and development depends on the health and well-being of children. Children are a supremely important national asset, and the future well-being of the nation depends on how its children grow and develop. The great poet Milton put it admirably, and he said, "Child shows the man as morning shows the day." And study team of social welfare said much to the same effect when it said physical and mental health of a nation is determined largely by the manner in which it is shaped in the early stages. Just that much.
This is well taken, but you must show children in the context of same sex.
My lords, my respectful submission is from the perspective to show to your lordships that this architecture is carefully crafted, my lords. My lords, here, heterosexual couples also don't have rights that equate to them. My lords, there are categories within categories created. Man and woman don't have same rights. A single man and a single woman do not have same rights. So from that perspective, my lords, there is no, in fact, the only recognition is to the child's right. In fact, when I'll show to your lordships, my lords, your lordship saw that section 3, my lords, with me. My lords, then please come to straight away chapter 8 of the Juvenile Justice Act, my lords.
Since we've given you 30 minutes, we're already now 45.
I'm sorry.
So no, not at all. You made a very valid point, and you never, yeah, everything that you say is always very precise and full of substance. So just formulate your submission so that, forget the submissions, we'll read the submissions, of course. But if you can just formulate it, so that then we can take it down and then we can focus on it.
Lordships may go through only my note. Just part B is the portion that I've dealt with. I'm just going to quickly tell your lordship.
If you can just sort of highlight what are the key areas, because I think now we've seen the broad architecture, etc., of the law that you have showed us. You can formulate 3 or 4 key submissions, and then we can.
My lords may note, my lords, in the CARA adoption guidelines, the latest ones are of 23rd of September 22. That's at page 228, my lords, in this compilation A. And
just one second. Let's just take it 1 second.
2 to 8, my lords.
3rd of September.
My lords, this is 23rd September 22. These are the latest guidelines, but I put the old guidelines of 2017 also, and there are very little changes. The architecture continues in the same manner.
Ms. Pati, what page? did
My
you-
lords, this is page 228 in compilation A.
Compilation A.
And my lords, your lordships will pay close attention, my lords, is my respectful submission to the general principles governing adoption, regulation 3, regulation 4, child eligible for adoption. My lords, this OM that came was from steering committee, my lords, discussions. One point that was put was that child is trans. How is he dealt with in CARA guidelines? CARA guidelines make no distinction. What is the gender of the child? What is the disability of the child, if any? What age of age? Well, so protection is given only on 2 occasions. What is the age on which it is given? So Lordship will have a quick look at regulation 5. That gives, my lords, regulation 4 gives child who's fit for adoption, and regulation 5 gives eligibility for adoptive parents. That's at page 230, my lords. Your lordships will see that man-woman relationships are immaterial. So a man cannot adopt a young girl child. And it is in this manner, my lords, that it has been crafted. Then 2 years of stable married relationship is extremely critical. My lords, that your lordships will find in regulation 5. My lords, I also want to draw your lordship's attention to, my lords, seniority in regulation 44 and root search in regulation 47. My lords, seniority, your lordships will find,
Sorry, regulation 44 and
regulation 44 deals with seniority of prospective adoptive parents,
and
and my lords, regulation 47 deals with root search. So every child is entitled to a root search, adopted child also. When either if he becomes a major, he's entitled to do that on his own or through his adoptive parents. And my lords, in the entire architecture, only at one place the biological parents' rights is protected. That is regulation 47, subregulation 6, where it says that the right of an adopted child shall not infringe the right of privacy of biological parents. This is the only place. So if biological parents wish their privacy to be protected, then this root search will not be given. My lords, I've given in yesterday's compilation a flow chart of how adoptions happen, my lords. My lords, I've given a data also. In fact, I took from CARA data. You'll also find that at page 1 of my yesterday's compilation. Roughly, my lords, I've given gender-wise. How many boys, how many girls for the last 8-9 years? How many have been given up in adoption? How many parents have registered? So roughly, to give your lordships an idea, there are about 30,000 parents who are registered prospective adoptive parents waiting for adoption. And the children, my lords, here who are in the pool are less than 1,500. There is a mechanism for, my lords, you have to reserve every prospect. And then, my lords, there is a mechanism for intra-country is the last
I mean,
resort.
only 1,500 children are available for adoption across India.
My lords, yes. And not yet available. They are in the pool. They're my lords, because there is a time period that's available for children who are surrendered. Their biological mothers or parents can reconsider if they want to. So there is a mechanism that is laid down, my lords. And then they are put in the, my lords, I've given a flow chart also of how adoption happens. It is only through Caring's portal. No interference by humans. It is a portal that is automated, my lords, completely. The option goes to the next in seniority as a prospective adoptive parents. They are given 48 hours. They have to give their ethnic background, their choice, gender choice. My lords, the home study form that's a schedule in this, my lords, in these regulations is so exhaustive. You have to disclose not just your health conditions, income, your parents, your other family members, your children. My lords, it is so comprehensive that because it's important where the child is, because there is a process of matching that has to happen. After the parent decides that this child might be fit, there is a matching that has to happen, and it's only after that matching that the child is, my lords, given.
just a question out of curiosity. We appreciate how
ma'am.
much effort has gone into ensuring that the child is safeguarded in every which way when he or she goes to a home. What is the timeline ordinarily for an application once a party applies, a parent to be applies, and it matures by actually handing over the child to that adoptive parent?
I've given that in my, that
Do
one.
we have data?
But 3 years.
Do we have data of
What is it?
neglected children who are in care institutions and who are not was not adopted, do after turning 18 go? I mean,
Have
I
you
won't use
done
the word
some
they are
time
turned
service?
because care institutions don't cater to any adult.
Yes,
At
ma'am.
the age of 18, if the child is not adopted or not cared for, in the sense that there is nobody to sponsor
Please, ma'am.
her or him, and he becomes an adult,
Yes, ma'am.
what is that? What is the future of that young adult who was a child till then? We have, I mean, there is no data. Actually, there is no data. And if you say 30,000 applicants are waiting,
Prospective parents.
Pending.
of prospective parents, then 1,500 only are available.
Yes.
Isn't it a matter for concern that we look into every care institution? And there are thousands. We have at least in Delhi itself more than 50.
My lords,
And
this,
Tamil Nadu, we have, I think, 250 or so.
my lords, this is the data of, well, if your lordships will see page 2 of my yesterday's compilation of legally freed children available as on 28th of April 2023. The CARA has guidelines prescribe a procedure in which the child has to be declared free for adoption. My lords, it's a very razor thin edge walk, my lords. The child is being separated from biological parents, surrendered parents, or orphan, my lords. Orphan also, my lords, there is a provision for family adoption because, my lords, our culture, we are polycentric even in families. There will be nani, dadi, masi, mama, buas, whole lot, my lords, and they have right of, my lords, accelerated rights of adoption for family members. So there is the whole process. If the process is not followed for declaring the child legally free first, before giving up in adoption, it is going to. I just want to quickly, my lords, just tell your lordships what the rest of my note is. Lordships will just see that, my lords, I have also, my lords, I've adverted to in between the ART and the surrogacy mechanism is also like that. I just quickly want to mention this, my lords, the National Board of Surrogacy and ART, they were referred some, my lords, issues that why are you not allowing donor gametes in a surrogacy? My lords, the answer very clearly that has come from them is emotional bond of the child is very important. We can't even take 1% chance. So they say between the egg, the sperm, and the uterus, at least 2 of them have to be of biological parents. So while ART allows donors, surrogacy, where you're using the uterus or womb of another woman, altruistic, no commercial, because now the regulation is very clear. You can't use donors. Though Malad's Code 5 will deal with those challenges, but the reasoning that has come is that there has to be a strong emotional bond of the parents who are going for these assisted mechanisms. Malads, we have given, I think I've covered most of it, Malads. I would draw your lordship's attention to, Malads, one more aspect. The special provisions with regard to children, to women, my lords, is also something that your lordships will have to look at very carefully. We have made a compilation of, my lords, laws where women are protected by virtue of their married or domestic relationships.
Thank you, Ms. Vativil.
And my lords, one more thing, we made a chart of these 34 countries which have in some manner recognized their civil unions, though it's a phenomena only of this millennium, my lords. But they have recognized, we made a chart, my lords, we've given a source of that also. 27 of them have gender neutral rape laws. Social fabric is different, my lords. That chart your lordships will find, my lords, in our compilation C at page 1492. The source is also there, my lords. 27 countries gender neutral, 4 are gendered, 3 we could not confirm because they were in languages, my lords, though we tried AI of the internet to get the sources. My lords, I'm very grateful to your lordships. I had, my lords, just written an opening line. Your lordships will permit, I'll read it, my lords, at my closing. The entire endeavor of ours is to present to your lordships that the architecture of child-centric or child welfare laws is very carefully crafted with welfare of child being paramount. Any general declaration reading in spouse instead of husband and wife will make laws relating to adoption, assisted reproduction, surrogate reproduction completely unworkable. Even for the legislature, my lords, which has the tools of wide consultation, expert and specialist advice, My lords, options of calibrated and gradual solutions, opportunities of amendment, savings and repeal. That to my mind is a very, very important tool, my lords. The option of adoption, savings and repeal. My lords, they will also find it very onerous responsibility to balance on one hand the competing rights and on the one hand protecting the parents' patria responsibility of the welfare of the child, because that is non-negotiable.
All right. Thank you, Ms. Bhatti. Thank you.
I am very grateful, my lords. Your lordships have given me this opportunity.
Yes, Mr. Maninder Singh.
My lord, only a couple of minutes, my lord, because the written submissions are already filed. My lord, if your lordship kindly have, my lord, the written submissions coupled with the small compilation of judgments, my lord, which are in our name. Because I tried to find out the PDF number, I was instructed, my lord,
No,
to.
We have the written submission.
Yes, my lord. Now, I have only 2 points to make, my lord,
What?
in support of the same submission.
What are the 2 points? You
Yes,
can just
my lord,
formulate
first
them.
of all, on the point, my lord, that under section 4 of the Special Marriages Act, by virtue of, by process of interpretation, my lord, it may not be permissible for recognition of same-sex marriages.
Just 1 second.
छोड़ दो यार, social motion नहीं करना था. Special Marriage Act.
Yes.
Well, under section 4 of the Special Marriages Act, all sub clauses are conditioned in
That's
addition.
the-
I don't want to repeat.
And what is
it.
the second point, Mr.
Second point is, my lord, on that as late as 2022, my lord, I have placed 3-4 judgments of your lord, my lord, of the different courts, which, my lord, 2 are Privy Council and 1 is from Hong Kong, my lord, where 2 out of the 3 judgments where similar rights had been claimed, my lord, were declined. And in one of the judgment, constitutional validity of declining this right, such a claim, which was placed before the court, my lord, is rejected. That is, that a provision we say, no, there would not be any recognition to same-sex marriages, which was put in question on constitutionality, is declined. My lord, if your lordship will just have a look at the judge, small note, my lord, I'll just
Yes,
show lordship the provision.
It's like that DOMA, the DOMA.
page
Yes,
18.
my lord.
DOMA was struck down. Here you say DOMA was upheld.
Yes, my lord.
Page
Yes, your
18.
lordship is right.
Page 18 of your submission.
Yes, my lord, if your lordship may just give me, only make a note, my lord, in para 14, we have also relied on section 112 of the Indian Evidence Act in support of the first submission. And then, my lord, if your lordships come to para 16, my lord, which is extremely important.
1/6.
Yes, 1/6 at page 7, where 3 provisions of 3 personal laws, my lord, where there is that ability to procreate, which is one of the conditions in section 4, is a ground for divorce. In all the 3, my lord, personal laws of Hindus, Christians, and Muslims, which is, my lord, mentioned in para 16. And then, my lord, if your lordships rightly, my lord, pointing out to
Those foreign cases you wanted to show.
yes, my lord, page 19 bottom, the Italian Constitutional Court, my lord, where the Article 29 of that, my lord, Constitution, which, my lord, is reproduced at page 11 of the note because a reference is made earlier. Just make a note of, my lord, Article 29, which, my lord, was very wide, much wider than section 4 of our act.
Article
where-
29, where, Mr.
My
Sorry,
lord, if your lordship may kindly see page 11,
21,
page 11 of the note,
right,
Para 21.
okay, thank you.
page 11 of the note, my lord,
This is that Oliari, the
Yes,
judgment
my
of Republic.
para 21, Article 29, if your lordship may kindly see the second part of it, marriage is based on the moral and legal equality of spouses. So, my lord, by repressing this word spouses when the right was claimed, my lord, that is declined at bottom, my lord, page 19 bottom, going up to the next page. Kindly see para 31. And, my lord, if your lordship permit me, I've kindly come to 20 and 21, extremely relevant, my lord, and your lordship may also keep 2 things in mind. The argument of discrimination and classification, which Mr. Dwivedi had also addressed, I don't want to add. And, my lord, the benefits to flow from such recognition. which, my lord, an argument raised here also, both the arguments raised, both are taken up squarely, my lord, directly, and, my lord, debated, considered, and declined.
You cited Oliari as well.
And, my lord, yes, my lord, and your lordships have considered Oliari in, my lord, the page's judgment, but if your lordship may kindly...
Para 34 is your Privy Council judgment.
Yeah, and, my lord, Privy Council, in one of the judgment, my lord, just give me a moment.
Of Cayman
That is
Islands.
Page 21, last two paragraphs above 32, both the grounds of discrimination and other benefits which flow from such a legal recognition of marriage have been considered. And if your lordships kindly come to 22, this is para 34 is the, my lord, first judgment of 2022, my lord, by the Privy Council, where, my lord, section 14(1) of Bill of Rights was, my lord, which is reproduced in para 34, and then, my lord, the consideration thereof is up to page 24 of my note, and, my lord, which was rejected. Kindly come to para 36, which is that section 53, my lord, of Domestic Partnership Act, which created a prohibition against such a recognition. It's extremely important, my lord, for your lordship's kind consideration. The Domestic Partnership Act of 2018, where section 53 created a prohibition, the constitutional validity was challenged, and, my lord, after consideration, at para 76 and 77 of that judgment, which is reproduced at page 24 and 25, it is rejected, my lord. In Hong Kong, my lord, which is para 37, which is also, my lord, 2022, a similar, my lord, discussion has taken place. Similar contentions have been considered. And if your lordships kindly come to page 27, my lord, para 77, kindly read, I'll just read para 77. Your lordship may kindly have regard to the other portion, and I have to place the judgment copy also in the second compilation. Kindly come to para 77. In terms of access to the institution of marriage, it concerns the special status of marriage, which is a distinct concept from the benefit arising from it. The difficulty or even perceived hardship involved in obtaining the benefits of means of legal challenges does not justify a shortcut bypassing BL 37, my lord, which is Basic Law 30.
All right, Mr. Mahendra Singh.
Thank you. Thank you, my lord. And judgments are, my lord, enclosed. The full text of the judgment is placed for your lord. I am deeply obliged, my lord.
Thank you, Mr. Mahendra Singh.
Please, your lordships. My lord, I appear for the Akhil Bharat Sant Samiti. I'm not going to repeat anything, my lord. Most of the points are already covered. In fact, I'm adopting, my lord, all the points. I've already filed written submissions. Only 2 points, my lord, I wish to highlight. A, Lord, the concept of marriage in the Indian society is creation of an institution. For example, in the Hindu law, it's a sacrament. Muslim law, it's a contract.
The concept of marriage in Indian society is?
Is, Lord, an institution by itself. Whether in Hindu law, it's a sacrament, so it is a divine angle. In the Mohammedan law, Lord, it's a contract. Now, various facets. Now, Lord, concept of same-sex marriage, therefore, would be virtually like an attack on the very institution of marriage, which has been traditionally known in this country. And Lord, we have to be very clear about it. There is no doubt that in Nautej recognizes the right to privacy. Lord, right to privacy is recognized, but your lordships have seen that, Lord, observation, where they have said, by this we don't mean the marriage, it's the union. Right. What is the second point, Lord, that I want to tell your lordships is, if your lordships have a look at the sections 19, 20, 21A of the Special Marriage Act, Lord, if you marry under this law, Special Marriage Act, then it's not connected to the Hindu Marriage Act, but it also provides that the two Hindus can marry. Now, if two male Hindus or Lord, two female Hindus marry thereafter, what implications is going to have on the other law? That also is required to be seen. Creating, Lord, a mere civil union is fine. That therefore there would be no problem about a civil union or a declaration that they need not be harassed, or because it's, the prohibition part, Lord, is a different aspect. But creating an institution of marriage itself, giving them all other rights, Lord, will interfere with all other
Yes.
So you are saying that there is no problem with a civil declaration of a civil union per se, but
Civil union, Lord, and that already has been given in the right to privacy. By privacy, you may, Lord, in fact, in my written submissions, I've highlighted and I've said so. That declaration of civil union is a different thing. But insofar as creating them as an institution of marriage will be virtually. And number two, Lord, India as a country, one has to see, like Roscoe Pound said, law is a concept of social engineering. It has to keep that. But India has not, Lord, reached that level where, Lord, this institution of marriage can be permitted at this stage. Lord, the rest of it, your lordships would get in my written submissions. I'm not troubling because there are other lawyers also who have to argue.
Thank you, Mr.
I'm obliged,
President.
grateful to you.
Mr. Sai Deepak will argue now, or Mr. Manisha will argue this.
Look, the state has filed an intervention application seeking to respond to various petitions praying inter alia for a judgment and judgment declaring the marriage between persons belonging to the LGBTQI community as legally valid in the context of the Special Marriage Act in the Hindu Marriage Act. Lord, my lord's ladyship, I've had the privilege of hearing the arguments of the Attorney General, the learned Solicitor General, and other counsels preceding me. I'll abide by uh, regulations circumscribed by the Honorable Court, one being the time constraint, the other being not reading out any judgments. My Lord, I've formulated a few points, my Lord, for consideration of the Honorable Court. But even those, my Lord, I shall not be going into in detail. Let me just briefly
Can you
relate.
formulate that, Ms. Lavkumar? So we can
I
just
have
formulate.
formulated them, my Lord. I'll just briefly read it. There's only one point on which I propose to take the Honorable Court, my Lord. My 4 points which I have formulated relate to reading up, reading down, updation of the existing law, governing marriage, especially the SMA, to include non-heteronormative unions would lead to altering of the cultural edifice. You know, substantially already dealt with by the other councils. I wouldn't delve any further into it. Necessity for a wide consultative process and comprehensive deliberation by the legislation, but it also has been extensively dealt with by the learned Solicitor General. This is what I wish to further, highlight this and the next point. It is not a case of exclusion or prohibition, but a case of non-inclusion in a targeted legislation enacted with special aims and objects. And this taking this further from the deliberations, as transpired in the court yesterday, tracing any right of recognition by whatever name called within or outside the framework of matrimonial laws would result in the creation of a new institution, dehorse the democratic process. My Lord, the inevitable ripple effect on numerous legislations, and my Lord, of course, my Lord, submissions with regard to the Foreign Marriage Act would get covered in the submissions already made with regard to the SMA. If time permitting, I'll make a 2-minute submission on that. My Lord, marriage as a socially recognized institution and the foundation of the Indian family unit, my Lord, I wish to submit that it is marriage between a man and a woman is at the core of the family. The Indian society is founded and organized around this concept of the family. My Lord, the rules of marriage continue to evolve, but they remain grounded in organizing of heterosexual relationships. My Lord, the interest of the state, considering the importance of this institution, my Lord, the interest of the state in regulating of marriage is, my Lord, lies in the overarching interest to preserve social order, ensure progression of society in a legitimate manner, and to regulate matrimonial conduct. In that sense, my Lord, marriage as a legal institution is not a private affair between consenting adults. It is a public act between two consenting adults who are then conferred a legal status by the state upon fulfillment of statutory requirements. My Lord, I then would point out that the SMA is part of a wider spectrum of all enactments relating to what we may be broadly calling matrimonial laws, whether in the realm of personal laws, whether SMA, whether FMA, all are heteronormative in structure. My Lord, I have excerpted by way of a table that all these laws carry certain features which would be considered as the core fundamentals or the thrust of the legislation. Namely, all of them refer to as heterosexual unions. All of them prescribe monogamy. All of them prescribe minimum age of marrying, and all of them carry prescriptions of prohibited degrees. They may vary from legislation to legislation, but all of them are uniform in that sense. Milord, the fundamental of marriage, Milord, before my lords, is a matter which has very serious uh, which has very serious consequences in terms of its depth and breadth, considering that my lords are examining not just the validity of an act, namely the SMA or the FMA. My lords are examining the very edifice of family institution, social structure, myriad of matrimonial enactments, and based on those myriad of matrimonial enactments, my lords have succession enactments, divorce provisions, maintenance provisions, adoption and maintenance. So it's an entire regime which is regulated. And all of it which is based on heteronormative. So it is an entire regime. My lord, looking at the act in isolation, my lord, would not be possible considering that it is all on the same platform. All heteronomous, all with these embargoes, all having regulatory nature, and all on the same platform. And built on this is entirely a regime of other enactments, and more importantly, social legislation, benevolent legislation, namely for Evidence Act 113A presumption, or Dowry Death presumption 113B, or Milord Dowry Death Act itself, or Milord Stridhan under the Hindu Marriage Act, Section 8. So there is an entire edifice which has been which is created around the institution of marriage.
You may read para 6 if you don't mind.
Please, my lords.
Page 11 of your note.
The rules of marriage continue to evolve, but they remain grounded.
Sorry, this is para 6 of page 11, social
Page-
institutions.
Brief note,
To the written submission.
para 6. My company.
After the chart,
Please, give me my.
the chart which you have given,
Yes,
so 2 pages later, this is part of note sub-para 3.
yes.
Yes, please read that.
Milord, the institution of marriage.
Yes,
The institution-
social
It's
institutions,
PDF 13.
PDF,
PDF.
PDF 13, yes.
PDF 13.
11. Printed 11.
13, Baba, come karo.
46 page,
Mera-
pages paper book.
Give me my compilation from there.
Social institutions.
Please. Social institutions consist largely of interlocking set of ideas that regulate or affect the way people actually understand and behave across interpersonal relationships. The meaning of social institution matters, and the institutions that bear it serve to structure our experiences and steer them in a particular direction. They define our goals, focus our attention on those goals, and direct us towards them. Changing the public meaning of a social institution leads to changing the institution itself. The concept of same-sex marriage is not within the percept of Indian personal law and legislation. Obliged. So, my lord, I have pointed out that the rules of marriage may continue to evolve, and they need must, but they continue to remain grounded in organizing heterosexual relationships. We have additional grounds for divorce being conferred. Over a period of time, my lord, even 21A seems to be is enacted in the provisions of the SMA to ensure that now Hindu laws relating to succession, etc., would be made applicable, and they must evolve, but the normative structure still remains heterosexual. My lord, taking further from that, my lord, over and above the interest of the state in regulating, my lord, I wish to point out to the Honorable Court my lord, the argument at which, my lord, the deliberation rested yesterday was with regard to tracing any right with regard to cohabitation into Article 21 as expounded, my lord, in Navtej. So, my lord, Navtej has already granted them the right to cohabit physically emotionally, sexually unfettered. My lord, my submission is that contemplating tracing of any right, of any legal recognition of the right to cohabit would amount to creating a new institution outside, my lord, the legal framework. My lord, an endeavor was made, my lord, an endeavor was made to read the SMA in a gender neutral manner. And the Honorable Court went through elaborately provisions as contained in Section 4C, provisions as contained in 4D. 4C was with regard to age, reading in a gender neutral manner. Age, for male, it was 21 years, female, it was 18 years, as sought to be made applicable to gays, possibly yes, to lesbians, yes, but they are not representative of the entire community. My lord, LGBTQIA. So there are.
Could you
that's
just,
some-
you've used a very interesting expression, uh, juxtaposing the argument of the petitioners to the bouquet of rights.
Yes,
You call this as the sanctification.
that's right.
Now, sanctification narrative, could you just explain this in 2 minutes? What do you mean by the sanctification narrative in the context of heterosexual relationships, heterosexual marriages?
My lord, my submission is that this principle of sanctification lies in the fact that the institution of marriage predated any legislation. Legislation legislation recognize this social, cultural, pluralistic acceptance of this heterosexual union across societies, communities, and regulated it in a manner that was most beneficial to public order, sustainability, procreation, ensuring the best upbringing of children. And the regulation does not end at marriage. The enactment provides not only entry points, also exit points, the manner in which you exit, an organized manner, grounds for divorce, maintenance, who gets responsibility for it. So this is an entire a genre, a regime created. Now recognition, the petitioners endeavored to look into this SMA as well as the FMA and read it in gender neutral manner. My lord, hypothetically, just taking the example of prohibited relationships under Section 4D. My act, please. My lord, under 4D,
Thank you, Ms.
yes, no, my lord, would my lords, I need to make one important submission. If my lords be pleased to turn to my note, which I forwarded yesterday. I wish to hurriedly go through that. I'll take 5 more minutes. My lord, it's a 5-page note mailed yesterday.
Yes.
My lord, part 3, consequences of any declaration.
Sorry, Ms. Lavkumar, there's a 9-page.
9-page note. I stand correct. It's a 9-page note. I'm only going on part 3. That's all I wish to, my lord, read.
Part 3.
My lord, it would be page number 3. Page number 3, part 3.
Yes.
My lord, any declaration of from this honorable court would have very serious ramifications. The edifice of matrimonial laws and ancillary laws are extremely regulated. Sans any regulatory regime, a judicial recognition would create serious social and legal issues. My lords, please to note, Section 4 had a bunch of regulations, age prescription, prohibition related, prohibited relationships, bigamy, etc. Any recognition would become a law within the meaning of Article 141, and it would be binding on, my lord, the entire judiciary, and plethora of litigation will come seeking recognition. But dehorse this regulatory regime. Tomorrow, my lord, Navtej only talks of consenting adults. What about prohibited relationships? What about bigamy? My lord, there is no regulatory regime. Any recognition dehorse this regulatory regime would have serious consequences. I also point out, my lord, that entry 5, list 3 of Schedule 5, Schedule 7 empowers the legislature to enact laws with regard to marriage, divorce, adoption, wills, etc. This court, my lord, ordinarily would not arrogate it to itself the lawmaking prerogative. My lord, it is further submitted that the petitioner's apprehension is completely misconceived that the parliament would not look into it.
Yes.
My lord, the apprehension of the petitioners in seeking recognition of either marriage, a relationship akin to marriage, or by any name called, is misconceived on the ground that the legislature would decline to examine the concerns of the entire community, seeking legal recognition within the members of such community. And it is only this honorable court which would declare. You know, my submission, this is a circuitous route. Ordinarily, the honorable court would leave it to the parliament. It has various multifaceted dimensions, all to be deliberated, social consensus, a large number of debates, and conflicting views. Those adversarial views are important to evolve, my lord, a consensus on this issue. When to be done, how to be done. Rather than go to the parliament, the first endeavor was read into the SMA. When not fitting into the structure of the SMA, now seek a declaration apart from the SMA, which would have even more serious ramifications. And all arguments which are made applicable in the context of SMA would be equally applicable, my lord, in this context. My lord, would my lords now turn to para 20?
I think we'll close it here, Ms.
Just one submission, my lord.
Yes.
By giving a declaration of the nature contemplated, my lord, this honorable court would unintentionally be foreclosing debates in society,
That we have.
foreclose the rights of society to
We have-
determine. And my lord, finally, my lord, such a declaration would hamper the genuine, organic, and sustainable change in society, which is reflective of the democratic ethos of the working of the Constitution.
Thank you, Ms. Milad.
My lord, I conclude by saying that, my lord, it's not a simple class of mere declaration of a result. It has very, very serious ramifications in considering the entire marriage regime and the ancillary social laws which are involved.
Thank you, Ms.
Grateful to
Thank you. No, we'll first hear Mr. Sai Deepak. He's got an order which has been given to us. Yes, Mr. Sai Deepak. Can you just formulate what will be your line of
with my lord's permission, given that I have only 20 minutes, and which I expect may not even happen, I'll do my best to simply formulate my position. And as opposed to reading out from anything, kindly allow me to just engage in the bench, because my written submissions capture my position that's already been shared. So there are two aspects.
Just give us 1 second. We'll just go to your written submission. So as we are arguing, we can also keep a track of your submission.
If I may, Minutes, an additional written submission.
Additional submissions or the original one?
The original. The additional is a one-page note, and I'll anyway address it. So my lords could perhaps refer to the first written submission.
So what is broadly the line of?
Minutes, if I may say so. The first law of thermodynamics effectively encapsulates the entire position when it comes to physics, and from there all corollaries flow. So the central position that is effectively placed before my lords is with respect to the distinction between fetters and powers, which is to say that this particular area which the petitioners seek to espouse before my lords is an area which falls within either prohibited areas, or is it something that falls within the area for my lords' adjudication? That is the central issue. And I think that is the forest that is thought to be presented before my lords. I am here to perhaps unpack a few leaves for my lords' consideration. The question of legislative competence is just one aspect of the issue which hinges on separation of powers. But I go a step further, which is to say that when the petitions raise the question of change in heteronormative attitudes, does the society have a right of agency to participate in these proceedings or not, at least in this particular issue or not? Because this is not a question of separation of territories between different organs of the state, but it fundamentally hinges on the right or the agency of the society to participate in this particular discussion. And that is the central problem when these kind of issues and subjects are taken up by the court of law, as opposed to leaving it for legislative prerogative to apply its mind. Point number two, during the course of these proceedings of the last 2 weeks, quite a few times I've heard the submission being made that it's a liberal democracy, it's a liberal document, so on and so forth. Does it mean that social conservatism has absolutely no place within the meaning of the Constitution? Does it mean that the society does not have the right to draw a few red lines to basically say thus far and no further? That is the central question. I represent a women's organization which equally represents the right of children. And therefore, as a civil society organization, the question that is being raised is that the nature of the prayers raised in the petition has the consequence of individualizing a socio-centric institution such as marriage, which is to say, as long as it is a transaction that takes place between two individuals who are consenting and who are not prohibited by any prohibition of degrees, so to speak, the rest of the society has absolutely no say as far as this institution is concerned. This, I'm sorry to say, fundamentally demeans the institution of marriage and takes away its social character. So these are the meta questions that I think which arise for consideration before this honorable court when these kind of petitions are filed. I'm sorry to say this, and let me try and perhaps tone down the rigor of my submission to the extent of saying, I believe that they have a cause. I just don't believe they have a case. The cause is different from the case. And it is important for the court to seriously consider one aspect here. When there are issues of legislative competence, there's another figure, so to speak, which is involved. And that figure's powers come under Article 111 of the Constitution, which is to say that if a legislative proposal ultimately meets with the consent of both the houses, ultimately it has to go to the Honorable President. And the Honorable President also has the power to recommend amendments to a legislation. Therefore, this is not just a question of legislative prerogative or legislative sovereignty, either from an external or an internal perspective, but there are multiple dramatis personae and stakeholders of this particular equation, the society being the chief, because ultimately the petitions raise the question of changing the paradigm with respect to heteronormative attitudes of legislations in general. It is not just about the SMA. Plus, my lords, is not dealing with the religion-specific legislation here, it is the SMA, which means all the more the society's participation when it comes to the SMA is warranted, is mandated, is compulsory. Because at least if it were to be with respect to certain, let's say, religion-specific legislations, it can be said that there is an identifiable group which has a locus to argue here. But when it comes to the SMA, it can't be the argument that only those who subscribe to the values of SMA are allowed to participate in these proceedings. Secondly, as has been already submitted, Section 21 of the SMA has a direct bearing on personal laws. So even with respect to SMA, the society has a right to participate. The reason why the additional written submissions become relevant is because I filed an annexure, which is the Manual for Parliamentary Procedure of 2019, which was published by the Ministry of Parliamentary Affairs. And that particular manual, so to speak, has Chapter 9, which deals with the business of legislation. Close to 30 clauses exist detailing the manner in which a legislative proposal is to be considered in the first place, how the ball is set rolling. And in that, if I may just refer to my additional written submission here, I'll walk my lords through the relevant portion here. Additional written submission, my lords, has a copy been given to the other side? Please hand it over.
We have it here.
Please, minutes. So para 1 effectively has captured my position with respect to Article 111, but the second paragraph is where I placed reliance on the Manual of Parliamentary Procedures. Does my lords have it?
Yes, we have.
For the benefit of the bench, may I just read this out?
Which para?
Para
9.2?
2, page 2.
Para 9.2?
Exactly. So para 2, so I'm reading out from the written submission because that
okay.
captures.
Right.
And the document itself is annexed. So let me just read out the submission, minutes. May I?
Yes.
Please. Does the rest of the bench have it?
Yes, in addition to the above.
Please, in addition to the above. So can I just read out para 1 for the sake of completion? I'm so sorry. May I? Please.
Yeah.
It is humbly submitted that apart from circumvention of legislative prerogative and sovereignty, violation of the doctrine of separation of powers seriously impinges and encroaches upon presidential prerogative under Article 111 of the Constitution. Under the said article, firstly, the Honorable President has the right to receive the bill for his assent after it is passed by both houses of Parliament. This translates to countervailing obligations on the Parliament to present the bill for the Honorable President's assent. Further, under the article, not only does the Honorable President have the right to withhold assent, but also the power to recommend amendments and also reconsideration of certain specific provisions in a certain bill. Now, paragraph number 2. In addition to the above, reliance is also placed on the Manual of Parliamentary Procedures issued by the Ministry of Parliamentary Affairs in July 2019, which contains a specific chapter, Chapter 9, titled Legislation. My apologies for the speed. I'm just trying to keep up with time here, please. The said chapter spells out in great detail the steps to be undertaken in promulgating a legislation. Critically, clause 9.2 deals with the pre-drafting stage of a legislative proposal, which is divided into 4 broad stages that include consultation between the concerned ministry to which the legislative proposal relates and the Ministry of Law and Justice. Critically, the latter ministry shall review the legislative proposal for legal and constitutional feasibility, validity, as also, and here I quote, necessity and desirability of such a proposal. Clause 9.5 envisages approval of the cabinet followed by an assessment under clause 9.6 of the expenditure involved. Critically, clause 9.7.1 envisages securing the recommendation of the Honorable President after the introduction of the bill, which is different from the assent sought under Article 111. Then, my lords, clause 9.12 speaks of the possible referral of that particular bill to a select committee or a joint committee or for circulation for public opinion. If I may say so, and I say this with the deepest of respect and the greatest of humility that I can command at this point, that the judicial mechanism cannot be a substitute to any of these steps, especially when it comes to such a serious issue. And I draw from Hindu law here that the purpose of marriage or the object of dampatya is a child, is procreation. Now, therefore, comes the central question with respect to all the permutations and combinations that my lords posed by way of circumstances. What happens to a single child? What happens to a single parent? What happens if it's a homosexual single parent? So on and so forth. Allow me to answer this question in a slightly different fashion. Public morality is decided by normative attitudes. The norm is decided primarily by the mainstream. This is not a majoritarian argument. This is a statement of fact in a democracy. Point number two. When normative attitudes are sought to be revisited, to say that those who constitute the norm don't get to participate in this discussion because that particular process and that particular, let's say, dance of democracy is sought to be circumvented by using the instrumentality of the court to secure a certain outcome, I'm sorry to say, defeats the purpose of advocacy. Those who are interested in convincing the society are expected to engage with the rest of the society to make good their cause. The judiciary cannot be a substitute to this particular process, because then that effectively replaces societal cogitation with, I'm sorry to use the words, judicial paternalism. That can't happen. Three, the benefit of revisitation of a judgment with respect to such sensitive issues, even if it exists by way of clarifications, I'm sorry to say is not an adequate substitute, it's a suboptimal substitute. Because if the principle that has been established by several judgments is that a judgment is not to be read in the manner of a statute, then there is no precision which can be imparted to the language or findings. And therefore, the principles of statutory interpretation don't apply. So we are left with greater uncertainty. Please. The point that I'm perhaps trying to make, and which is what I'm trying to draw the court's attention to, is that the Nalsar judgment that they placed reliance upon extensively, there is a plus and there is perhaps a downside to it. The plus is the judgment must be read in its context. And the issue was the recognition of a third gender. That was what it was limited itself to. And therefore, to extrapolate the findings of the particular judgment, which primarily concerned itself with self-perception, self-identification in the context of gender identity, to extend it to a marital transaction or a marriage-like transaction is to read a judgment for what it is not. Secondly, there are only three in places.
I think we perhaps are aware of how to read these judgments.
Please.
We don't need to be taught.
No, Millets, I'm sorry. I understand. I'm just placing reliance on this. I'm just making
Yes, we understand that these are contexts.
Please.
Whether they're analogies or not is up to us.
My lords, please, Millets. I'm grateful. The second point is, in fact, on a closer reading of this particular judgment, certain inconsistencies emerge between the two opinions of the very same bench in terms of what constitutes sexual orientation, what constitutes gender identity. Now, that is natural because there is a discussion that's going on there. It is not to be read in the same manner as a statute. In fact, therefore, the judgment, which doesn't exactly help their position, also points to a certain problem with respect to judicial revisitation of some of these aspects. And the judgment of Arun Kumar of the Madras High Court is actually in the teeth of the submissions being made here. which is to say narrow language being expanded through judicial interpretation contrary to legislative intent and history, is to rewrite legislative history, and judicial reinscription, which is retrospective in nature, may not be exactly permissible. That's one. Then, the submission with respect to international law, all the general instruments apart, the Yogyakarta principle, specifically clause 24.e, specifically leaves it to countries to decide if they wish to have recognition with respect to marital unions. So it's not as if there is some kind of a binding precedent here, or there's no international instrument that says that you shall. I'm not arguing for it should not be. Kindly let this caveat is important. I'm simply saying, if the door of judicial intervention in this matter is open for one case, even though the cause may be worthy, what does it do for the future? Because ultimately, it's not just a question of one matter. It's a question of the future as well. So therefore, there are specific aspects that relate to the issue in question, and there are general aspects that relate to the separation of powers and societal participation that go well beyond this matter. In light of this, my lords, my only humble submission is that there are other issues to be dealt with, and allow me to just point this out and use this particular forum to advocate only one aspect. Having actually engaged with certain transgender activists and also having worked with them, I know for a fact that one of the biggest problems is trafficking, them being pushed into prostitution, them not having legitimate livelihoods. I am not reducing or dismissing anybody's concerns with respect to what is their priority. Let me clarify that. I'm not making that submission at all. But these are certain Maslow's needs which have to be completed first and which have to be addressed first before we get to the next step. That's all I have to submit. I'm so grateful for the kind pleasement. It's great, deeply obliged.
Now, Mr. Imar Shamshad.
I have submitted 4 pages notes, my lord.
We'll have a look at the note. Can you just identify the most critical
Yes.
point that you want to make?
2 points I'm trying to convey, my lord, because Mr. Sibal, Mr.
Just come straight to the point.
They have already argued. My lord, as far as the matrimonial legislations are concerned, those statutory legislations 50 onwards, even in those legislations, there are scope of customs, practices, which have been practiced for a long time. Undefined practices are part of those legislations. I have cited, for example, only 4, 2 from Hindu related Hindu religion law and 2 from Muslim. For example, section 3A and 29 from Hindu Marriage Act, my lord.
Yes.
Section 3A of Hindu Adoption and Maintenance Act 1956. They take custom within the statutory regime. Those are not defined.
So how do you formulate it?
My lord, even in the statutory regime, undefined customs and practices
Yes.
of community and those who follow religious beliefs have been made part of the statute.
See, 4C proviso of the Special Marriages Act.
My lord.
He itself talks of subject to custom, and then it says how custom is to be, proved.
My lord. So that is there, and we don't know ultimately what custom is finally proved in certain facts and circumstances. That will depend upon case-to-case basis. Same way in Muslim related legislations, my lord. In section 3 of Muslim Women Protection of Divorce 1996 Act, there are practices of Muslims which have been recognized. 1939 Act of Dissolution of Muslim Women, that sets out ground for divorce, but there is a provision which says that other grounds which is acknowledged in Muslim personal law. So those have to come from uncodified sources of personal law.
What is the next point?
Next point, my lord, even if we talk Special Marriage Act, my lord. Reading of section 19 to 21A takes us to custom within 3B T 73 of Hindu Succession Act. Section 19 to 21, if we read it together, detailed discussion has taken place on this, my lord. It takes us to Hindu Succession Act 3BD73. And they are uncodified customs.
All right. What is the next?
If we go to 27(1)A, my lord, then that takes us to Hindu Adoption and Maintenance Act 3A, read with section 10, clause 3. So this is one, my lord. Second, as far as declaration is concerned, the declaration that has been sought for from that side, I completely adopt the arguments of Mr. Dwivedi, learned Solicitor General, Mr. Kapil Sibal. My lord, if your lordship declares this right, I just want to flag one or two problems. Within the realm of personal laws, those that relationship may not be recognized, and it is not recognized in many personal laws. At the same time, we have certain statutory bodies which only regulate religious affairs, like Hajj committees, like certain shrine boards. They only regulate religious affairs. Like if somebody goes tomorrow to Hajj committee and says, I have constitutionally declared right to remain as union, and I want to go on Hajj as couple, married
We'll have
couple.
to wrap up now. Yes.
So that I have 2-3 examples that I have set
Already
out.
we look at the.
These are the problems which will be faced by even statutory bodies that you.
All right.
So
Thank you, Mr. Shamshad.
I'm
Call
deeply
up,
obliged.
Call upon Ms. Priya Aristotle, please. Thank you, Mr. Shamshad. Thank you.
I'm deeply obliged.
Sorry to cut you short, but we are now.
No
Thank you.
problem.
We'll read your note. Yes, Ms. Aristotle.
Much obliged, my lord. I stand here representing a student, Jerusha Joel, and I have 3 lines of argument only, my lord. One is about the history and the marriage aspect, which is social, and about the canvas, which my lord opened up. Normally on a canvas, we want to see who's
You've
behind.
given us written submissions?
Yes,
All
so I will not get deep into it, but how much is necessary. And third is the ASG addressed about the adoptions and the kids. But what about our children who are going to school? They have been receiving a lot of propagation which has been going on, and we just need a little protection for them at this tender age when this is being done on a day-to-day basis in the name of gender clubs. So the first is, as we all know, the word normally used here, even in IPC, was sodomy. The origin of this is the sin of Sodom, which comes from the Bible. And
what's the core of the submission? Tell us the core of the submission.
I just want to bring up the historic aspect.
No, don't give us history. Give us the core of the submission.
Minute, that is all.
Yes.
So I just want to say that we are not following the Victorian law, but it originated 5,000 years back, and it's basically the Jewish law that we follow. And that is how all this was abolished, like adultery, monogamy, sodomy, sati, everything was there, but all that came with the Reformation, which was gone on with it. Now they've come for legalizing it. As long as people do not come to legislate certain things, there are many things that are happening. Like I've visited ashrams, like because my family comes from a set of
One
beliefs
should,
where they are
so long
not
as
egalitarian
we got your
at all.
Yeah.
In fact, they must be incest.
It has to be in the form of legislation.
Exactly. But if these people, this group is going to come and ask my lords for legislating it, definitely it's a no. But if it is going to happen behind the doors, nobody is going to be bothered.
Everybody's made that point now. I think we can.
Yes.
Anything else? Anything else which has not been covered?
Absolutely, my lord. Now going behind the canvas, who is behind the canvas? Internationally, it's not just in this court. I was listening to the the US court arguments, the audio of it. Literally, it's a replica of what's happening there and in many other nations. There are no new submissions that are made. So
all right, thank you, Ms. Aristotle. I think we'll close there. Yes. Thank you, Ms. Aristotle.
Yeah.
Now, what about Mr.
One thing about the UN agenda, my lord. Recently, not very long back, recently I have submitted my thing, so I'm just not going to get into it. But very recently, they have come with principles, more than 20 principles. And principle number 16 is about consensual sexual conduct. With the new principles coming in, my lords doesn't have to worry about the age factor, whether it's going to be 18 or 21, because UN has come up with a guideline saying that you don't have to, even if they're minors, if they're going to consent for sexual things, it cannot be criminalized. And again, it goes on for 18, it says sexual orientation. Anybody can guide a minor to get into. It comes there, my lord, I have marked it at page 119 to 144 are my UN agenda thing. So again, our children who are going to school, every other day there is a propagation of this that is going on, and they need to be protected. In Russia, there's a thing against propagation of...
Thank you, Ms. Aristotle. Now we'll hear Ms. Manisha Narayan Agarwal.
Much obliged.
Thank you, Ms. Aristotle. What's the punch point?
Punch point, Your Lordship, only. Lordship, my punch point is in the first para of my written submissions, Your Lordship. The question I asked myself is, can there be a declaration of, can there be a declaration that an absence of recognition is void? And what will be the consequence of such a declaration, my lord? Will the consequence of such a declaration be creation of the recognition? And there is only one parallel which I will draw is, there was a time when our statute recognized joint and several liability partnerships, but did not recognize limited liability partnerships. Could someone take up the Partnership Act as law under Article 13(2) and pray to this honorable court to recognize, to declare as void the absence of limited liability partnerships?
All right. Thank you, Ms. Thank you. You got the point.
Obliged, my lord.
Thank you. Mr. Joby Verghese.
Yeah, Your Lordship. Sasmit Patra.
Yes.
I'm representing two organizations. I'm also at a personal capacity as a member of Parliament of Rajya Sabha.
Yes, Mr. Patra.
Your Lordships, two basic points, 2 minutes and I'm done. First, capacity of Parliament. That has not been taken up. We've talked about separation of powers, various things, capacity of Parliament. I'll elaborate on that. Second, role of politics.
Just 1 second,
I'm sorry, Your Lordship, I'm having to rush because of the time. But
what was the argument, Mr.?
The argument is capacity of Parliament. I've filed a 3-page submission report in which the fourth para, if you see, there is a table.
Just give us 1 minute. So what we'll do is we'll come back after lunch. We'll give you 5 minutes after lunch.
Thank you, Your Lordship. Deeply obliged.
I need five to
Certainly.
I'll not repeat anything.
Certainly.
Of course,
you're not.
Your Lordship's leave to upload the note in rejoinder, my lord, which will be the basis for the submission today.
All right. Yes, certainly.
Great.
My lord,
in 501.13, council is appearing online, my lord.
Come back after lunch.